number 1.
I don't to mention my lord. Item 32. 32.
32 which list, sir? Weekly
is-
list, special weekly.
My lord.
Yes.
Petitioner expired, my lord.
Ah.
Let the matter, maybe I filed memo just now.
Memo. There's no instructions. This was not resolution.
Obliged.
Lord, may I be pardoned? Item 46. I have got no instruction.
Okay.
Only meantime, it has become infructuous.
I'm for
All
the
right.
petitioner also. I have no instruction also.
Sorry?
I am for the petitioner. No instruction.
All right. He's for
Item
whom
1,
then?
my lord.
I am for OP.
You're for OP, I see. Conflict of petitioners, the party state neither has instructions. Dismissed or not? Disposed of. It's disposed.
Item 1, my lord, we have no instructions.
Okay, no instructions. Dismissed or not?
Old matter item number 2. Item number 2, I am for Bhubaneswar Development Authority.
All right, none appears. Dismissed or not?
Special weekly list item number 3.
None appears. Dismissed or not?
Special weekly list item number 4.
None appears. Dismissed or not?
Special weekly list item number 5.
Accumulated or the tax effect is 27,000. Tax effect is 27,000.
In view of the insignificant tax effect, question of law is left open. The petition is disposed.
Special weekly list item number 6.
6, my lord, there are defects. In fact,
How many days delay, sir?
delay is, my lord, 14 days.
All right.
Unfiling of process fee. by the
Yeah,
petitioner.
you say that process fee hasn't been filed for over 13 years now. Dismissed for non-prosecution.
Special weekly list item number 7.
Again, incomplete requisites,
Here, my lord, 23,000 is the tax.
insignificant tax effect. It's disposed of.
Special weekly item number 8.
None appears. Dismissed for non-prosecution.
Special weekly list item number 9.
May I please do notes? This matter stands covered by a lordship judgment which relates to purchase of paper on basis of Form 4 and sale of paper on Form 1A, my lords.
All right.
The questions of law at page 6 of the brief, my lords.
All right.
Their lordship have answered the question in favor of the SSC.
You say admit the following questions of law are framed for consideration. From page 6. In view of the judgment of this court dated 11th April 2022 in the STREV 21 of 2008. Bracket Messrs. Rameshwar Lal Sham Sundar versus State of Orissa. The above questions are answered in favor of the SSC and against the department. The revision petition is disposed of.
Quickly, please.
Special weekly list item number 10.
None appears. Dismissed for non-prosecution.
Special weekly item 11.
None appears. Dismissed for non-prosecution.
Special weekly item 12.
My lord, there are defects.
All right. Defects have not been cured for over 13 years now. Dismissed for non-prosecution.
Special weekly list item number 13.
None appears. Dismissed for non-prosecution.
Special weekly list item number 14.
My lord, tax effect is 9,000 some odd.
All right. In view of the insignificant tax effect.
Special weekly list item number 15.
My lord, there are also defects, requisites.
Defects have not been cured for over 13 years. Dismiss for non-prosecution.
Special weekly item 16.
16, there are some defects, my lord. May I be permitted to rectify it because I was
Not after 13 years, sir. Sorry.
I was not aware of it, my lord.
No, it's all right, sir. How much is the delay?
Delay is about a year, 1 year, 1 year. Is the only thing because the at the time of receiver notice thereafter super cyclone was there, 99.
That's all right. Sir. These are all 13-year-old matters. So defects have not been
This
cured
is
for
some
over 13 years.
consequences.
There's also unexplained delay of satisfactorily. There's a delay of over a year in filing the revision petition, which delay has not been satisfactorily explained. Consequently, the petition is dismissed.
Special weekly list item 17.
None appears dismissed for non-prosecution.
Special weekly list item 18.
None appears dismissed for non-prosecution.
Special weekly list item number 19.
Remember, 60,000 is the tax effect.
All right. In view of the insignificant tax, the questions of law are left open. Petition is dismissed.
Special weekly list item 20.
None appears dismissed for non-prosecution.
Special weekly list item 21.
Not 82,000.
All right. In view of the insignificant tax. All right.
Special weekly list item 22.
Remember, 16,000.
16,000 disposed of.
Special weekly list item 23.
5,000.
5,000.
Special weekly list item 24.
May I please, your lords? This is a matter covered by your lordship's decision in the full bench case, my lord. The similar same assessee is before this honorable court while challenging the assessment order, my lord. And that assessment order has already been decided basing on the Tilakaraj Magistrate case, and that decision was full bench decision. Covered by this decision. He is also party in that case, my lord, for that assessment that year also. Same year. Manisha Enterprises, my lord. I have also mentioned in my miss case also that number is also mentioned. There is pending before this honorable court. In page paragraph 5, I have also mentioned that OJC 1338399 is pending before this court in full bench, my lord. Meanwhile, it has been decided that so it is maybe remitted back to the tribunal to do it after keeping in mind of this full bench decision.
What's the tax effect here, sir?
Amount is 1,15,000. But it is covered.
My lord, may I see the judgment?
It is covered. This.
The question's been framed here, sir.
In the full bench decision, para 7, my lord, that the decision has been clearly been stated that Tilakaraj Magistrate case, my lord. And in the last paragraph, this order, they have hold that, court has hold that the Tilakaraj Magistrate case is also right decision.
Is the right decision?
Right decision, Tilakaraj Magistrate. Basing on which the question has been framed before this honorable court.
All right. This revision petition is admitted on 3rd May 2010 and the following question was framed. It is now pointed out that by virtue of the full bench decision in Manisha Enterprises versus State of Orissa. What is the citation here, sir? This must be a reported judgment, sir.
Reported judgment, my lord.
What is the citation?
It is not, it is normally it is not comes in the
No,
magazine.
reported, sir. Some effort you have to make for that.
So it is mentioned Manisha Enterprises versus State of Orissa, my lord. Decided on 20th.
All that we were able to read that, sir. I would just want to know the
No, it is
reported.
not reported. So
It is obviously reported, sir. You have not made the research
my
to
lord,
find out.
I'm sorry, man.
Decision dated 20th February 2015 in OJC number 13383 of 1999. The decision in Tilak Raj Mediratha versus State of Orissa has been affirmed. Consequently, the impugned order date 9 June 2008 of the Orissa Sales Tax Tribunal conduct in essay number 1248 of public 98-99 is hereby set aside, and the said matter essay number 1248 oblique 98-99 is remanded to the tribunal for a fresh decision in accordance with law. The matter will now be listed before the tribunal on 11 July for further proceedings.
Special Weekly List item 25.
None appears to sustain no opposition.
Special Weekly List item 26.
None appears to sustain no opposition.
Special Weekly item 27.
27, in view of the counter para 12, this case is now infructuous.
Whom are you for, sir?
I am for the petitioner, my lord.
All right. Counsel to the petitioner states that the matter has been rendered infructuous. It is disposed of as.
Special Weekly item 28.
28, my lord, on behalf of Mr. My lord, he is out of station, my lord.
1 minute. You are for the petitioner or for the
Opposite,
respondent?
my lord. Opposite, no.
We'll see who's for the petitioner. All right.
Mr. Mudul is on his legs in court number 3.
All right. Pass over.
Special Weekly item 29.
None appears to sustain no opposition.
Special Weekly item 30.
None appears to sustain no opposition.
Special Weekly List item 31.
None appears to sustain no opposition.
Special Weekly item 33.
Lord, this 33 item, it's a service related matter. It is the assigned bench is a single judge.
You are for the petitioner.
I am for the petition.
Counsel petition states that this is a matter to be heard by a single judge. Placed for the assigned bench on 11 July.
Special Weekly item 34.
Not this.
Not pressed. Dismissed is not pressed.
Special Weekly item 35.
None appears to sustain no opposition.
Special Weekly item 36.
None appears to sustain no opposition.
36, my lord, I am for the petitioner. My lord, my video has got some problem. I am Dipti Ranjan Mahapatra, school and master. My lord, my
You're not
video
for the
has
petitioner, sir. You're for the opposite party.
yes.
Dismissal non-prosecution.
Special Weekly item 37.
None appears to dismissal non-prosecution.
Special Weekly item 38.
Dismissal non-prosecution.
Special Weekly item 39.
None appears to dismissal non-prosecution.
Special Weekly item 40.
None appears to dismissal non-prosecution.
Special Weekly item 41.
My lord, I am appearing for opposite party.
None appears to dismissal non-prosecution.
Special Weekly item 42.
None appears to dismissal non-prosecution.
Special utility item 43.
None appears. Dismissed now.
Special utility item 44.
None appears. Dismissed now.
Special utility list item 45.
None appears. Dismissed now.
Special utility item 47.
47, you also look to the prayer person. I am for the opposite party.
Oh,
The private opposite party number 7. Prayer has been made.
all right. 1 minute.
I think it has become infructuous. Practical also look to that.
None appears to the petitioner. Mr. Rautril and senior counsel for the opposite party states that the petitioner's praise have been rendered infructuous. Dismissed for non-participation. The contempt petition is also disposed of.
Special utility list for orders item number 48.
Lordship, on item 47, for the contempt petition on behalf of Mr. Komiratha, it is no instruction is there.
All right.
All right. Item 48.
The last paragraph. All right. The note, office note has been perused. The corrected.
Yes, please.
The order be corrected as indicated. Minor correction.
Item 49.
MC, yes. The order is corrected as indicated. Yes.
Item 50.
Same here. The order be corrected as indicated.
One passes. Special utility list passed over matter item number 28.
Mr. Mudali was to appear.
Mr. Das, item 28.
28, my lord. Mr. Mudali was supposed to do, my lord. He's on his legs. I'm only praying tomorrow, my lord. I'm sorry for
Day after tomorrow.
All
They have
right.
not compared section 7 my lord.
All right.
Till date,
I'm sorry, my lord. He's held up.
All right. Day after. Day after.
day after tomorrow.
All right.
Weekly list.
Supplement. Supplement. Oh, I see. Okay.
Weekly list fresh admission item number 1.
Wait, please, Lords. Lords, in this matter, what has happened is the government of India had floated a socially beneficial insurance scheme under which the opposite party number 2 was supposed to enroll certain beneficiaries through private individuals through a system of smart cards, Lords. Lords, I was empaneled as a smart card service provider for 5 districts, Lords. That is Angul, Dhenkanal, Jagatsinghpur, Keonjhar and Nabarangpur.
Yes, please.
Lords, during this enrollment process, Lords, if Lords can turn to page 18. In Malot's page number 18 is an email, Malot's, by the opposite party number 2, directing me to pay certain amounts out of my pocket to certain field officials, Malot's. Malot's, similarly on page 19, again, there are instructions that I have to release certain incentives to the field workers, Malot's.
This is a contract.
Malot's?
This is a contract.
Malot's.
And it's with an insurance company.
Malot's.
So why should we entertain a writ petition?
No, Malot's, my only is that I have made certain expenditure on.
Is there an arbitration clause in the contract?
No, Malot's. This empanelment was done by the central government, Malot's. There was no explicit contract as such entered between me and the insurance company, Malot's.
Then on what basis are you carrying out the tasks?
Malad, I was empaneled by the state government. My name was reflected as a smart card vendor in the national website, Malads. And Malads, I have enrolled hundreds of beneficiaries under the scheme for the government, my lords. And my lords, I'm only aggrieved by non-reimbursement of my admitted dues, my lord.
This is actually recovery of dues, sir. Why should you file a writ petition for this?
My lords, I am in financial distress, my lords.
That may be, sir. Writ petition is not the answer. There'll be several disputed questions of fact here.
My lords, not disputed, my lords. Not disputed.
From your point of view, sir, from your point of view, nothing is disputed. Correct?
My lords, if my lords may just turn to one letter, my lords, my amount is also admitted, my lords. It's not that it's disputed, my lords. My lords may see page 39, my lords. My lords, page 39 is a letter written to the special secretary to the government by the opposite party number 2, my lords. My lords, in this.
So you made a representation?
Yes, my lords.
When was that made?
My lords, my representation was on 4th December 2021, my lords.
What have we been doing since then? It's 18 months now.
No, my lords, we've been in continuous correspondences with them. But my lords, they are not, it's not fructifying into anything, my lords.
No, the payment has to be made by the insurance company or the government.
My lords, the payment has to be made by the government. The government has released.
But your representation is to the insurance company.
My lords, that money has been released by the government to the insurance company. Now they have to give it to me. My lords, even if a direction that my admitted dues, whatever they admit, my lord, even if they pay that much, I'll be grateful, my lords.
The prayer is confined to the direction to be given to the insurance company.
That's what I thought. Representation you say the petitioner's representation dated 4th December 2021 shall be disposed of by the regional manager, New India Assurance Company Limited, Bhubaneswar, in a period of 4 weeks after giving a hearing to the petitioner, and in any event not later than 1st July 2022. The decision be conveyed to the petitioner not later than 8th July 2022. If agreed by such decision, be open to the petitioner to seek appropriate remedies in accordance with law. The petition is disposed of.
Obliged.
The petitioner will communicate the order, this order, to the opposite party for appropriate action forthwith.
Weekly list test admission item number 2.
May I please, your lordship? Lordship, this is a challenging to notice issued under section 148, my lord, of Income Tax Act, beyond 6 years, my lords, bad by limitation, and this is fully covered up case, my lord, in view of my lord's sort of.
Who's for the other side, sir?
TK Satpathy, sir.
Where is he? No, but if it's covered, then all right.
Lordship, so far
Notice, he
second.
accepts notice. It is not in dispute that these petitions are covered by the decision of this court in Ambika and Steel.
Yes, 20919 of 2022. WPC number, Ambika Iron and Steel Private.
All right. That be the matter, the impugn notices are hereby quashed. And all consecutive proceedings are hereby quashed. The petitions are disposed.
Weekly list item number 3.
No, sir. Sorry, sir. 2 second item. 11362. Sorry, Lordship. 11362 of 2022 is concerned. Lordship, this is a challenging to reassessment order without supplying reason of reopen.
So that's only the first matter. 11359. 11362 is what?
Well, this is a Lordship. This is a second time reassessment, my lord, by the department. They have not supplied the reason of reopening in spite of my request, repeated request, my lords. And this is a covered case, Lordship. GK and drive shot, my lords.
Not covered in that sense, sir. 11362, you just say notice, he accepts notice. To the extent of hearing, no course of steps should be taken in his submission. Reply we filed within 4 weeks. Rejoined of minutes. It's on 1st August.
May I not?
Weekly list item
Sorry,
3.
Lord. Item 1 is covered, but item 2 is not within 6 years.
So 2 we should notice, sir. Mr. Satpathy.
Deeply good.
Item 3, sir.
Item 6, my lord.
Made thing. This is the revival of the repetition pursuant to order dated 5/8/2019. There has been no perceptible improvement in the situation, my lord. Regarding the construction of drain number 7, though the government had the plan to do it by in the year 1996, after filing this repetition even and after the assurance given by the
this is
in the counter.
1 minute. This is in Cuttack.
My lord, Bhubaneswar.
I see.
Lord, the BMC in the previous state petition, the BMC has filed the counter. And it counts in paragraph 14, they have stated that the construction of the drain work will be completed by end of monsoon 2020. Now the allegation of the petition.
Who's for the BMC? You're for the BMC.
I am for BMC.
What are the instructions?
Our difficulty is that your lordship knows by end of question did not arise because of the COVID. Because lot of staffs engaged in for.
We don't know all this, sir. You file an affidavit.
That will do. But one thing is that land acquisition problem is there. The acquisition process is going on.
Whatever you have to say, you put it.
That is the problem because government have to help us. We have given the land acquisition
notice
process.
He accepts for government.
And the only thing I indicate.
Who will accept for BMC?
OP number 6 he has made in the name party. That is to
It
delay.
only says BMC.
BMC OP number 6.
Our part copy says BMC through the commissioner.
In state copy also he has mentioned the name of the commission.
In the state copy he has mentioned. I don't
The copy we have is says BMC through the commissioner.
Let him give copy. I don't have the copy.
All right.
Give him copy.
I have given a copy to the state government. I will be filing a copy. I will be giving a copy to him.
All right. Extra copies be given to both. Replies be filed within 4 weeks. The joint up for the next week. 6th July, sir.
Weekly list item number 4.
This counter affidavit is already there.
The previous one, the counter affidavit filed in the previous state petition.
That's what is wanted.
The lordship directed copy to be given to me.
Yes, sir. Yes.
Let him delete that name.
Yes.
Item number 4.
Item number 4, my lord, the challenge is to the notice under section 148, my lord. The similar without giving personal hearing and without considering my reply.
That is, my lord, other cases have been posted to 29th June, madam.
I have given a similar order. My lord may stay the further proceeding.
No course of action be taken. 29 June. Right.
Obliged.
Weekly list item number 5.
Lordship, item 5 may permit to place this matter. Lordship, only I require only breathing time, Lordship, because 10 days today is expiring, Lordship. I have received the certified copy, Lordship, and SLP number I already I have obtained.
After referring an SLP law, my lord friend is making a prayer for a period of surrender.
They will always insist on your surrendering, sir.
Lordship, kindly grant me only 2 weeks time, Lordship, because Lordship can see my position of my
You have
son.
to ask, if you filed SLP, you should ask there, sir.
Lordship, in
Normally,
fact,
this
no,
prayer is
Lordship,
made in the Supreme Court.
Lordship, in fact, Lordship know the position of Supreme Court because
we don't know.
No, matter taken
No,
up.
no, sir. We don't know at all.
No, matter taken up only by 20th, Lordship.
What way? We don't know, sir.
Oh, Lordship, kindly. Visual is one situation, Lordship. My son is at coma stage, Lordship.
Whatever, sir.
Lordship will client can only breathing time only 7 days, Lordship. Lordship, because matter taken up by 20th, today is date of surrender. Only Lordship grant
Once
week
you
time,
filed
Lordship.
Supreme Court, sir, we can't do this.
Lordship,
Once you
grant at least 1 week time, Lordship.
Sorry, sir. Considering that this petitioner is already, applicant is already approached the Supreme Court with a specially petition, the court is not inclined to entertain the present prayer. The application is dismissed. Yes.
Weekly list for orders item number 6.
Item number 6, my lord. My senior's father has passed away today, my lord. My lord, kindly be taken up after vacation, my lord.
You are not audible, sir.
My lord, 6, my lord. May I audible, my lord?
Now you are.
May I audible, my lord?
Yes, please.
My lord, my senior's father has passed away today, my lord. My lord,
All right. Answer to the petitioner is stated some difficulty today. List on 29th June.
Obliged, my lord.
Weekly list item number 7.
Instead of 35%, it should be 45% of disability. I pleaded in my petition in page 4.
IA number 6306 of 2022.
I've also annexed it. Page 23.
For the reasons stated, the application is allowed. The percentage of disability is corrected as 45%.
45%.
Quick list item number 8.
Acharya is appearing for the petition. Seeking for pass over.
Item number 8.
I'm on behalf of Mr. Acharya. Kindly grant us a pass over, Your Lordship.
This is covering to your lordship's order that the 29th other cases.
I see. Notice, the access notice. List on 29 June till the next date, no coercive steps to be taken.
Quick list for orders item 9.
Please, Your Lordship. My Lord, it is that Prawn Gary 10 days notice matter, my Lord.
So you have to file now.
My Lord, 10 days, my Lord, before 10 days, on 21/4/2022, they have issued notice me under Annexure 4, my Lord. Until today, DLC has not communicated what is the fate of our application, my Lord.
Well, as per my telephonic instruction, my Lord, DLC has in fact forwarded the application to Coastal Aquaculture Authority, my Lord. So, but since my Lord,
then how can you issue the demolition, stopping the prawn culture? Or
what they have stated, my Lord, it is coming under the CRZ zone, and any kind of construction.
CRZ zone permission registration is required, my Lord. STL line 200 meters, no prawn culture can be done. But within the CRZ zone, 2 kilometer registration is necessary. Beyond 2 kilometer, no registration is necessary, my Lord. Therefore, we have, as it is in the CRZ zone, we have applied for registration. DLC has recommended. Now they have issued a notice for.
So I think the same order that we passed that earlier.
Yes, yes, my Lord, that your lordships have passed that.
Lordship had adjourned to July.
Undertaking not to carry out. Yeah.
Yes. My Lord, what they are doing, they are committing the content of this honorable court, my Lord. Deliberately, they are violating the order of this honorable court.
Counsel, the petitioner points out that petitioners are running the prawn cultivation within the CRZ zone and have accordingly applied for registration. Mr. Das, appearing for the opposite parties, states on instructions the petitioner's applications have already been forwarded to the Coastal Aquaculture Authority and their responses are awaited. In that view of the matter, it is directed that no, you say then Mr. Manoj Kumar Mohanty, the counsel petitioner states that without prejudice, the rights and conditions of the petitioner will stop carrying on prawn culture till further orders of this court. In view of the above assurance and subject to the petitioner adhering to it, no coercive action will be taken to demolish the petitioner's aquaculture farm till the next date. Reply be filed within 4 weeks, adjourned for the next date.
But meanwhile, the Lordship may also direct the Coastal Aquaculture Authority to take on, to take a decision on such recommendation, because pursuant to Lordship's
Coastal
order.
Aquaculture Authority, are they a party?
Yes, Mr. Party is not here.
Opposite party number 5.
Well, in second case, my Lord,
will take
my farm has been registered since. In second case, my Lord, second repeat. So my farm has been registered since 2010, my Lord. Registered for 5 years. It was renewed. Then, my Lord, after expiry, I have applied for renewal. Renewal is pending before the Aquaculture Authority as per the provision of 1311, my Lord. If they don't want to renew, they should give an opportunity of being had. Till today, nothing has been done, my Lord. Now they have issued notice for stopping.
Red Petition 11931 of 2022. When did you apply for extension?
My Lord, my registered certificate is under annexure.
No, when did you apply for renewal?
Renewal, my Lord, I have applied, I have given my Lord. I have applied on 4/1. I'm giving. Dead. I have applied on 5/4/2020, my Lord. 4/1/2022, my Lord.
Counsel, the petitioner states that the petitioners applied for renewal of registration on 4th January 2022 and the said application is pending with the Coastal Aquaculture Authority. then you say, he further assures the court that without prejudice arising condition to the petitioner till the next date, the petitioner will not carry on. Till further orders of this court, the petitioner will not carry on any prawn culture activity. This is subject to the petitioner complying with the above adherence. No course of action to demolish the petitioner's aquaculture farm will be taken. The Coastal Aquaculture Authority is directed to convey its decision on the petitioner's request for extension of registration, renewal of registration before the next date. Replies be filed within 4 weeks, rejoinder for the next date. Based on, say, 6 July. What's the third matter, sir?
Hold on, my lord.
Third matter.
Third matter, my lord, that DLC I have applied, it is for consideration before DLC. Whether they have recommended,
So
they have
third,
not.
third matter, the same as first. All right.
Well, first matter, just order like first matter.
First matter, correct. All on 6 July.
Weekly list item number 10.
Petitioners who are the customer of the bank, who are also handicapped persons and old ailing person and pensionary, the bank has merged the branch of the bank with another bank where it is situated in first floor and there is no lift facility. And most of the customers are the old person and pension holder and there is no parking facility at all. And we have ventilated the grievance and it is in violation of the RBI guidelines also. And they are going to shift it to the place where adjacent to the NH, there is no parking place. And earlier it was situated where all parking place and in the ground floor. And these I have given the photographs, handicapped persons and the pension holders, they have been deprived of to take the service of the bank because they cannot go up to the first floor without any lift and no parking facilities. In 1981, it was functioning, bank was functioning. And RBI guideline says that they have to take prior approval of the.
When did the shifting take place?
Marat?
When did this shifting take place?
Shifting, they have Annexure 2, kindly they have given this notice, Annexure 2, on 11/1/2022. Now, the present position is that they have closed the branch, but not shifted and they are not functioning the new branch in the new branch. They have only closed that previous branch bank. But we are the people who have ventilated grievance to all the authorities and also to the RBI, also to their regional office, and they are keeping it in hold and no action taken thereon. And they have given the deadline 15 days. Now today it is finished, the 15 days deadline. They have not taken any steps. And most of the SOG ladies peoples are there. And in the new place, it is in the first floor, no lift facility, no parking facility, and accident prone area adjacent to the NH near Chaudhar. And it is a very old bank. 1981, it was established in this OTM premises, near OTM premises. That is very convenient and congenial to the people to go for their get the service.
Bank branch should be in X place or Y place. Is that a matter of
No. We have nothing to say, but if we cannot take the facilities, first floor, how we can go up handicapped person? No lift facilities
How
there.
many such handicapped persons are there?
No, these are they are pension holders, and it is also adjacent to the NH and accident prone area. And RBI guidelines I have annexed also. They have to take prior approval. They have not taken any approval, and no committee approval has been taken. And they have only in a whimsical manner they are going to.
Where are your representations?
It is in Annexure 3, page 37. That should be. There is modalities to shift the bank. They have not followed it.
The petitioner's representation dated 14 February 2022 will be considered by the Indian Bank Zonal Office.
Yes.
Bhubaneswar, and after hearing the petitioners, a decision shall be taken thereon and communicated to the petitioners not later than 1st July 2022.
And status quo should be maintained, my lord.
What status quo, sir?
My lord, because then it is become infructuous.
All right.
Where we stand then? We cannot get the facilities of the banks. Then your lordship may call for them notice. I will take special messenger. Let them appear.
Solid. Yes.
Weekly list item 11.
May I pray that let them not to take any action, status quo may be maintained.
Not for these kind of matters.
And your lordship may notice them, special messenger.
No.
Because they have not, we have given the representation, they have not considered.
So that we passed an order first. All right.
What they have already taken step, now what they will pass, given deadline. We have protested before in the locality.
All right.
It will become fruitless, my lord.
Yes.
No,
Yes.
they have not considered.
All right.
And RBI guidelines also they have violated.
All right. All right.
Item 11.
Item 11, pursuant to your lordship direction, I had issued a notice to the client, my lord. Yesterday they arrived and they intimated that the opposite part number 4, to whom the notice was issued, has passed away, my lord. In the morning, I have already filed a substitution application, my lord. That is IN number 6563. That is the sole private opposite party number 4.
In this matter, my lord, I am appearing for temple administration, my lord. This is the only shop left inside Anand Bazar. Now the situation is completely changed because of the status quo order, my lord. We cannot take any steps.
Correct.
As I got information from the supervisor temple administration, he said that this is the shop, my lord, in a dilapidated condition, and it is unsafe for the devotees also because it is approaching to Meghnad wall, my lord. Your lordship knows, my lord.
Right.
The only shop left. Because we have not, and this is interstate dispute, my lord, between their family. The OP number 4 is their family members, my lord.
Right.
So the appellate authority, while disposing the appeal, my lord, has said that the alternate remedy is civil court.
My lord, in the meantime, what has happened, the instruction I have obtained from my client that those old shop rooms have been, my lord, reconstructed, and this shop room number 10 has been numbered as shop room number 10 and has kept the allotment of the same has been kept abeyance due to the status quo order, my lord.
So you will get a nice reconstruction shop elsewhere, sir.
No, my lord, what has happened?
Once your interstate dispute is sorted out.
No, my lord, there is no interstate dispute.
That is the order, my lord.
No, my lord, what the appellate authority has done is, he simply has said that it is an interstate dispute between the parties which is to be adjudicated by the civil court, my lord.
Yes.
And in effect, my lord, he has decided the appeal by passing an order of direction to the opposite party to take possession. My lord, on the last occasion, the matter was partly heard, and this honorable court was of the view that since the opposite party is to be heard, before this, therefore the notice was to be issued.
But they say now the situation itself has changed on the ground.
Yes, my lord,
This is the only shop left there.
No, my lord, there are total 10 shop rooms reconstructed. The shop room number 10, which is the subject matter of dispute here, is still there, not being allotted.
In a dilapidated condition.
No, my lord, that has been
also, no one is in physical position, my lord.
That's
it is only vacant because of the status quo.
Yes. My lord, this is vacant because of the status quo order, and this is not in dilapidated condition. That is a newly constructed shop room, my lord.
No.
That is a newly constructed shop room.
How can it be a newly constructed? Sir?
Well,
this interim order itself, this is matters since 2006, right?
Yes.
Status quo was ordered in 2006.
Yes, ma'am.
How can there be a newly constructed shop?
No, they have, my lord, kept the shop
16 years old shop can't
Yes,
be a
my lord.
newly constructed shop.
My lord,
Sir.
either it is to be granted in favor of the petitioner or the opposite part number 4.
No, maybe not granted to anyone at all.
No, well,
The obviously has to be removed.
The
shop
agreement
itself
is a licensee.
No, the question, my lord, the question here is,
and nobody's in possession. If nobody's in possession, what's the point in having simply
My
a
lord,
structure?
No, my lord, what has happened? The reason behind nobody is in possession is the appellate authority has passed a direction to hand over the possession to private opposite number 4.
Right.
Now, in the meantime, private opposite number 4 has died.
Right.
Therefore, the vacant I cannot enter because the status quo order is
Anyway,
there.
this has to be sorted out in civil courts.
No, my lord,
You say, counsel the petitioner informs the court that opposite party number 4 has expired. Paragraph. Counsel appearing for the temple administration states that this is the only shop that is left within the temple premises.
And Anand Bazar, my lord, inside
That is
Anand.
within the Anand Bazar. And it's in a dilapidated condition because of the status quo order that has been enforced for 16 years now. Nobody is in possession as well. Paragraph. The court sees no purpose being served in keeping an unoccupied shop in a dilapidated condition. Continue within the Anand Bazar when all other shops have already been relocated.
Yes, sir.
Consequently, the interim order is vacated. The impugned order directing that the party should resolve the disputes in the civil court is reaffirmed. The petition is dismissed.
My lord, may I pray for one liberty if your lordship permits? My lord, so far as the petitioner entitlement is concerned, let the liberty be granted to the petitioner since there is no opposite party to approach.
No, why? The opposite party has got legal representatives. Obviously, they will have some stay in this matter.
My lord, there is no opposite party number 4 as such, as on date.
No, they have their legal representatives. In fact, you started off your submission saying you want to bring their LRs on record.
My lord, what my humble submission is, let the petitioner's entitlement be kept open and let that be adjudicated by the committee itself.
No, sir. Right.
Obligation. Weekly list item number 12.
Well, my lord, on last date, your lordship has directed the State Council, Mr. Mohanty, to file an affidavit in response to the affidavit filed by the ASI, my lord. Lord, I pray 2 weeks time more, my lord.
Your lordship, my lord.
2007 matters, sir.
My lord's order have not been complied with fully. Your lordship passed an order on 26th June 21 to file a response to the counter filed by the opposite parties. That has been filed, my lord. I have filed it, and I have made a comments over the content by the counters. They are not, but your lordship wanted that the wall to be completed for the protection of the area. That has not been completed so far.
What is your response?
My lord's orders have not been complied fully.
No, they have not been responded to the affidavit.
An action plan is supposed to be filed, my lord, by the district administration. Since my lord Sisupalgarh area, in fact, in the last order,
you were to file a response. Mr. Mohanty sought 4 weeks time to respond to the affidavit of the ASI.
At the last chance, your lordship may kindly grant us 2 weeks time, my lord, file it.
As the last opportunity, the state government is granted 4 more weeks to respond to the affidavit of the ASI.
Response to my lord's order.
The order
counter
dated,
I have filed on 28th July.
The order dated 15th March 2022 must be strictly complied with. Must be complied with while filing the said affidavit. List on rejoin to Feni there to file with the next day. List on 18 July.
Weekly list item 13.
15 years have passed, my lord. 15 years have passed to protect.
What to do, sir? What to
protect the land.
Correct.
May I please, my lord? The insurance company repudiated my claim on the premises that the permit of the vehicle was confined to Orissa and the vehicle has traveled to Chhattisgarh where the theft took place, my lord. This contention was negatived by the insurance ombudsman. Said it is not valid ground. But on the ground of delay, the claim was rejected. The theft took place on 31st of January 2010. I went to Chhattisgarh to trace the vehicle. That is the normal reaction of a person whose vehicle has been stolen. He first went to the spot to trace the vehicle. He couldn't find it. Then on 5th of February, after 4 days, information was given to the police commissioner regarding the theft and also to the insurance company lodging the claim, my lord. This 4 days gap, my lord, it is delay, my lord. The ombudsman says it is delayed because you have lost the information after 4 days, 5 days, and also inform the police after 5 days. Your lordship may see the reasoning, my lord. Your lordship. Paragraph 9 of the impugned order, page 11. The first ground, it was negatived by the insurance ombudsman.
Yes.
Paragraph 9, my lord, of the impugned order, page 11. Though the ombudsman held that only ground is Your lordship may see paragraph 6 first, my lord.
Right.
Paragraph 6 of the impugned order, page 9. The letter of repudiation dated 14/4/2011 of the OP would show that the claim was denied to the complainant by the OP on the sole ground that permit issued in respect of the vehicle so-and-so was valid for Orissa, whereas the incident occurred in Chhattisgarh, a place which is beyond the permit area, my lord. And the finding, if your lordship sees, as page 11, my lord. Page 11, paragraph 8, last 2-3 lines, my lord. It has been noticed that in the policy schedule under the limitation as to use, there is absence of the stipulation that the policy covers use only under a permit within the meaning of MB Act 1988 or under section 66 of the MB Act. In such circumstances, repudiation of the claim on the ground that there was a breach of permit by use of the vehicle at a place beyond the permit area cannot be countenanced. Well, next page, my lord. Next paragraph, sorry, my lord. Turning to the next aspect relating to the delay intimating the loss to the insurer and the policy, the copy of the FIR filed with the complainant himself would show that on 31st January 2010, the complainant was informed by his driver over telephone about the theft of his vehicle. And the report would show that incident was reported to the Commissioner of Police Bhubaneswar by the complainant on 5/2/2010. The other papers filed with the complainant would show that above report was sent to ACP John Bhubaneswar by the Additional Commissioner of Police Bhubaneswar on 8/2/2010 for inquiry. However, the copies of other papers filed by the complainant would show that again on 22nd February 2010, a report concerning theft of the vehicle was lodged with the IIC Kharabala PS. Though the OP has taken the stand that FIR was lodged on 22nd February 2010, it does not dispute lodging the report of theft of insured vehicle on 5/2/2010 before the Commissioner of Police. Thus, it is clear that the first report regarding the theft was given to the police on 5/2/2010. It is the contention of the OP that intimation about the loss by theft was given to it by the insured on 5/2/2010, my lord. Then if you also see the last line, my lord, the policy condition, a printed copy of which has been filed by the OP, provide that the insured is to give notice of loss of insured vehicle by the theft in
time
writing.
limit there.
My lord?
In the policy, there is no time limit within which complaint must be given. It only uses the word immediately.
Immediate, that's what, immediately.
Word immediately can be interpreted in so many ways.
Yes, my lord. Yeah, there is a
24
there is
hours.
judgment, my lord.
No. Where if it is 24 hours, the policy should say 24 hours.
No, immediately means your lordship visualize that vehicle theft was committed at Chhattisgarh. No FIR was lodged there. FIR was lodged at Bhubaneswar.
Sir, if your policy mandates that the complaint must be given within 24 hours.
The judgment laws that immediately has been defined.
The word immediately could mean anything from 24 hours to 5 days to 10 days.
No, the decision, Appeals Court decision says that immediately there a theft took place on the same day FIR was lost, but the intimation to the insurance company was given later on. There the Honorable Appeals Court says that no insurance.
Later on means how much later on?
No, regarding delay intimation to the insurance company, the Honorable Appeals Court says that that delay will not matter. Insurance company has to pay. But the FIR has to be lodged on the same day, my lords. Previously, delay in intimation to the insurance company, claim was repudiated.
Which paragraph? There it is 4 months delay, sir. Please read para 8.
No, that delayed intimation to the insurance company was. FIR was lodged on the same day. Paragraph 13, your lordship.
No, where does it say that if the FIR is not lodged on the same day, the claim can
Previously,
be
the law was that if the FIR was not lodged and there is delay in intimating to the insurance company is not liable to pay the amount. This decision says that if FIR is lodged on the same day and there is delay in lodging intimation to the insurance company, then certainly there is violation of condition number 1. Your lordship may come to para.
Will you answer my question, sir?
Yes, my lord.
Does this decision say that if the FIR is not lodged on the same day, the insurance company can repudiate the claim? Does the decision say that?
Yes, your lordship may come to para 22 of that judgment.
Don't simply say yes. Please follow the question very carefully.
Yes, my lords.
Does the decision say that if you do not lodge the FIR on the same day, the insurance company can repudiate the claim?
When previous laws were that if the FIR, they delay in lodging the FIR and delay in lodging to the insurance company, then the insurance company is not liable, my lords. That 2008 Supreme Court decisions. Your lordship may call this matter after vacation. I'll bring all the decisions.
No. It's okay. Don't immediately ask for an adjournment. Do you have a decision which says unless the FIR is lodged on the same day?
Yes, my lords.
The policy can, the claim can be repudiated?
Yes, my lords. There are decisions.
Which decision?
That 2008 Supreme Court. I have not brought that.
No. You give us a citation. We have all the AIRs here. Which decision?
Yeah, in this decision, it has been those decisions have been discussed, my lord.
Well, let's see where.
Para 9 onwards, my lord.
Let's see that.
Para 8 onwards, may I please, my lord? The condition which falls for consideration in the present case is the identical with condition that fell for consideration in both cases, namely Om Prakash and Pravesh Chandra. In the Pravesh Chandra, the vehicle was stolen on 18/1/95 and on 21/95. The FIR was alleged theft of car was registered on 21/95. However, the intimation was given to the insurer.
So the only decision in all these cases is delay in intimating the insurance company will not be a reason for repudiating the claim.
Yes, that is the law.
That is not the issue here, sir. You are trying to say that unless FIR is lodged on the same day, the insurance company is not obliged to entertain the claim.
This is the same decision.
I'm sorry, sir. This decision simply says delay in intimating the insurance company will not come in the way of the claim being honored.
Because the FIR was lodged on the same way.
No, that is what you're trying to read into it, sir.
May I place that this decision, lords? Everything, all the previous decisions have been discussed, lords. Given to the insurer on 22/5/95, on account of delay, the claim of compensation was repudiated by the insurance company for breach of policy. In the said case, the district forum had allowed the complaint of the claimant, which order was maintained by the state commission as well by the national court. However, reversing the concurrent orders, this court held that though the theft had occurred on 18/1/95 and 21/95, the intimation to the insurance company is given only on 22/95. It observed that no explanation for such unusual delay in informing the insurer was given to the claimant. This court found that in terms of the policy issued by the insurer, the respondent was duty-bound to inform it about the theft of the vehicle immediately after the accident. It further observed that on account of delay in intimation, the insurer was deprived of legitimate right to get an opportunity conducted into the alleged theft of the vehicle and make an endeavor to recover the same. Para 9. Per contra, in the case of Om Prakash, the vehicle was stolen on 23/3/2010. The claimant lodged an FIR immediately on 24/3/2010. He lost the insurance claim on 31/3/2010. Since the claim of the claimant was repudiated, he filed complaint before the district forum, which was allowed. The State Commission was also maintained the order of the district forum. However, in the revision, the National Commission reversed the same. In an appeal, this court found that the claimants had assigned the cogent reasons for delay of 8 days in lodging the complaint. It further found that the word immediately cannot be construed narrowly so as to deprive the claimant the benefit of settlement of genuine claim, particularly when the delay was explained. It further held that rejection of the claim purely on technical ground and in a mechanical manner will result in loss of confidence of policyholders in the insurance industry. It further held that if the reasons for delay in making the claim is satisfactorily explained, such a claim cannot be rejected on the ground of delay. This court also held that it would not be fair and reasonable to reject the genuine claims which have already been verified and found to be corrected by the investigator. It further held that the condition regarding the delays shall not be sheltered to repudiate the insurance claims which have been otherwise proved to be genuine. This court observed that the Consumer Protection Act, so this is not relevant. We are of the view that much would depend upon the word co-op and immediate in condition number 1 of the standard form of commercial package policy. Before we analyze this case any further, we need to observe the rules of interpretation applicable to a contract of insurance. Generally, an insurance contract is governed by the rules of interpretation applicable to general contract. However, due to the specialized nature of contract of insurance, certain rules are tailored to suit insurance contract. Under English law, the development of insurance jurisprudence is giving credence to Lord Mansfield, who developed the law from its infancy. Without going
so the whole issue here is about delay in informing the insurance company, sir.
No,
The issue here is not about when was the FIR registered.
No, here belongs two issues. One is delay in lodging the FIR, so also delay.
Where is the issue of delay in lodging the FIR in this decision? In any of the decisions that are cited here,
in this decision,
in any of these decisions, there is no delay in lodging the FIR. In none of these decisions.
No.
In each of these decisions, FIR is registered either on the same day or the next day.
Your Lordship, again, I am placing paragraph 15. We find the second part of condition number 1 deals with the theft or criminal act other than the accident. It provides that in case of a theft or criminal act, which may be the subject of a claim under the policy, the insured shall give immediate notice to the police and cooperate with the company in securing the conviction of the offender. The object behind giving immediate notice to the police appears to be that if the police is immediately informed about the theft or any criminal act, the police machinery can be set in motion and steps for recovery of the vehicle could be expedited. In case of a theft, the insurance company or a surveyor would have limited role. It is the police who...
So where does it say here in this discussion, the word immediately means same day?
Yes, may I be permitted? Read thereafter. In case of a theft, the insurance company or a surveyor would have a limited. It is the police who, acting on the FIR of the insured, will be required to take immediate step for tracing and recovering the vehicle. Per contrary, the surveyor of the insurance company at the most could ascertain the factum regarding the theft of the vehicle. Para 60. It further to be noted that in the event the registration of an FIR.
Do you doubt about genuineness of the theft?
Because vehicle was stolen at Chhattisgarh.
No. Do you doubt
Yes,
about genuineness?
Yes.
What are the materials with you to doubt about?
Because vehicle was stolen at Chhattisgarh. No FIR was lodged there, below. The jurisdiction under which the police the theft occurred, no FIR was lodged. FIR was lodged at Bhubaneswar.
No. Can it be that is the sole ground to doubt about the genuineness?
Yes.
No other ground.
Informing the insurance company.
Para 16 Millers.
Genuineness. Correct. No, this whole all this
Your Lordship may see.
intimating the insurance company. Not about it.
Your Lordship may see that paragraph 16 Millers. That will. It is further to be noted that in the event after the registration of FIR, the police successfully recovering the vehicle and returning to same to the insured, there would be no occasion to lodge a claim for compensation on account of policy. It is only when the police are not in a position to trace and recover the vehicle and final report is lodged by the police after the vehicle is not traced, the insured would be in a position to lodge the claim for compensation. As observed by the bench of two learned judge in this case of Om Prakash, after vehicle is stolen, a person who lost his vehicle would immediately lodge an FIR, and immediate conduct that would be expected of such a person would be to assist the police in search of the vehicle. The registration of FIR regarding the theft of the vehicle and the final report of the police after the vehicle is not traced would substantiate the claim of the claimant that the vehicle is stolen. Not only that, but the surveyors appointed by the insurance company are also required to inquire whether the claim of the claimant regarding theft is genuine or not. If the surveyors appointed by the insurance company upon inquiry finds that the claim of theft is genuine, the coupled with the immediate registration of FIR in our view would be conclusive proof of. So, if there is immediate FIR, that is the conclusive proof that vehicle has been stolen.
How do we know? That is not the decision here, sir.
What is the police investigation report?
My lord, my driver lost the FIR at Chandanpur. There, police refused to accept the FIR. Then police directed go and file the FIR in Orissa, my lord. This is the report, my lord.
No. What has happened in the last 8 years?
But the police filed a final form saying that culprit could not be traced, my lord. Not the vehicle could
not
be
that
traced.
the vehicle complaint is false.
Final report filed.
Once there is a final report which is saying that the culprit could not be traced, how do you conclude that the complaint is false? You're trying to say that the complaint is false.
Not, they have not produced that document before us. They straight away approached before the insurance ombudsman.
Where is the document, final report?
Yes, ma'am.
Why did you not give them the copy?
They have not even filed it before the insurance ombudsman. It has not seen the day of the light of the day.
Please give him a copy, sir. Where is the copy?
I'll give a copy of
Sir, if you want to succeed in your case, no point in giving us copy without giving him copy.
No, I'll give. These two are your lordship. I'm giving a copy, my lord. Just
When?
answer.
When?
Just now, my lord.
Give.
Yes. I'll just now, sir. I have one copy. I'll get it Xerox and give it to him. If I give you, I don't have the
So
copy.
you're in no hurry to get relief for your client.
No, my lord.
Yes. You are that 4 pages photocopy is going to delay your client's relief by 2 months.
Had it been filed before the ombudsman,
Because you're stinting on 2 rupees. You could not spend 2 rupees to give 4 more pages. Your client will not give relief for another 3 months. It's okay with you.
No, my lord.
If it is okay with you, we'll adjourn it.
It's not okay, my lord. I apologize for
Obviously,
that.
it is okay, sir. The most important document to support your case, you do not want to give copies. Neither to us, nor to him. This is because we asked you are giving us a copy.
Subsequently, I obtained them, my lord, because the client is not very cooperative and he's a poor fellow, my lord. So subsequently, I
So
got
he
it
can
from-
suffer.
No, my lord.
Naturally.
311, that is what I found. 311,
Client can
2011. This order was passed. Ombudsman order was passed, my lord, sometimes in 13. So 10/4.
When was this final form report prepared, sir?
2011.
3/11/2011.
And you've kept it in your file?
No, subsequently I got it, my lord. The client had this was not shared with me by the client, my lord.
How many witnesses have been examined? My goodness, 18 witnesses.
Life may lie in music, music may lie in life. You born to be free.
It's a no clue, Mr. Sarma.
Yes.
It's a no clue.
Yes.
No clue about the vehicle as well as the culprit.
Yes, madam. But nowhere they're not saying the theft has not taken place,
Nothing
madam.
prevented to lodge a report.
Even the insurance ombudsman is not saying that theft has not taken place. They took a plea that you have traveled beyond Orissa. Therefore, we will not entertain your claim, my lord. That was negatived by the ombudsman. And then ombudsman of his own found out a reason that there's a delay of 4 days. Therefore, it is not entertainable. Immediately, you should have filed the complaint, my lord. Well, in normal circumstances, I went there and to locate the vehicle, my lord.
If my learned friend's version is believed that police there didn't accept, nothing prevented him from giving a registered letter to the concerned SP of that area of Chhattisgarh.
This is a proper investigation that's been done, at the end of which there is a report.
If you don't doubt about the theft,
then you have to pay the claim.
Pardon?
It's all about genuineness of the claim.
Yes.
So you have no document or you have no material to show that the claim is not genuine.
No, we don't have any documents, my lords. We said that that's why the immediate, my lords.
No, he must have
next day-
submitted you the documents along with the FAR, the
The
charge sheet.
final form was not submitted, my lords.
No, final form. You have to collect it. Why should he?
No, they have to, under the conditions, my lord, they have to submit all the document, letter of subrogation, everything they
No,
have
where
to.
from he will get the final form?
But he's the complainant, my lords. How can I
No,
get?
complainant is not entitled to a final form.
Anyway, finally he's got it. He's got it. What is the date of the Ombudsman's orders? 10th April 2013.
13.
Why didn't you? You could have easily shown this to the
Yes,
Ombudsman, sir.
Then and there it could have been solved.
Anyway, now that you have it, you solve it. So many years have gone by. You say the short question that arises for consideration in the present petition is whether the Ombudsman was justified in rejecting the petitioner's complaint against the opposite party number 1 insurance company, opposite party insurance company, General Insurance Company Limited, in repudiating the claim of the petitioner regarding the theft of his vehicle, theft of his Chevrolet made Tavera vehicle. Paragraph. The background facts are that the vehicle was insured with under a policy issued by the opposite party insurance company for a period from 19th April 2009 to 18th April 2010. Stop. The petitioner was running a travel agency at Bhubaneswar, providing motor services to intending users on payment of higher charges. Paragraph. The insured vehicle was sent to a hotel in Bhubaneswar on 28 January 2010 for the purposes of taking passengers to a place in Sambalpur. Stop. One of the passengers then told the driver that his wife had taken ill and that they should be dropped at Chandrapur in the state of Chhattisgarh. Stop. On reaching the place, they halted in a dharamsala for the night, with the driver and one of the passengers sharing the room together. Stop. Unaware that the food consumed was intoxicated, the driver went to sleep. And on waking up, found that his mobile phone, cash, and keys of the vehicle had been stolen. And his room had been locked from outside. Stop. The driver then informed the petitioner of the entire incident. The theft took place in the intervening night of 31st January 2010. Paragraph. The case of the petitioner is that he immediately proceeded to Chhattisgarh to make efforts to trace out the vehicle. And when he was unsuccessful, sent an intimation to the Commissioner of Police Bhubaneswar on 5th February 2010 and also intimated the insurance company of the loss of vehicle on the same day. In the meanwhile, the police initiated a criminal case against Ravi Kumar Singh, who had hired the vehicle. Paragraph. The insurance company stated to have repudiated the petitioner's claim on the ground that the vehicle was valid for Odisha only, whereas the incident occurred in Chhattisgarh, a place beyond the permit limit. Paragraph. The petitioner thereafter filed its complaint under Rule 12 bracket 1 bracket E of the, what does RPG stand for? RPG rules 1990.
Redressal of public grievance.
Redressal of public grievance.
Redressal of public grievance rules 1998 before the insurance ombudsman on 1st May 2012. By the interim order dated 10th April 2013, the ombudsman dismissed the complaint on the ground that the petitioner gave intimation of the theft, not single quotes immediately, unquote, as required by the policy, but 5 days after the incident.
And also delay in lodging FIR. 2 counts dismissed. Delay in lodging intimation, delay in lodging FIR.
Right. Pursuant to the notice issued, a counter affidavit has been filed by the insurance company, pointing out that the affair was ultimately lodged in the Karavel Nagar PS in Bhubaneswar on 22nd February 2010. And the intimation given to the petitioner, to the insurance company, was on 5th February 2010. That is nearly 5 days after the occurrence. The exact wording of condition number 1 in the insurance policy reads as under, take from page 14, last paragraph, condition number 1. Paragraph, the word used is, open quotation, immediately, unquote. In other words, the condition does not state that unless the affair is registered on the same day of the incident, the claim cannot be entertained. Paragraph. Reference is made by the counsel for the insurance company to the decision Gurshinder Singh versus Shriram General Insurance Company Limited, AIR 2020 Supreme Court 1395, to urge that although the delay in intimating the fact of theft to the insurance company may not be single quotes immediate, the lodging of the FIR has to be done single quotes immediately, unquote. That is either on the same day or soon thereafter. Paragraph. Having carefully read the decisions, the aforementioned decision, the court notes that the main concern as far as insurance company is concerned is that the claim of theft must be a genuine claim. In other words, if there is anything to indicate that the claim itself is not a genuine one, the insurance company would be justified in repudiating the claim. Paragraph. While the delay in lodging an FIR may give rise to a doubt about the genuineness of the claim, that by itself would not be determinative of that fact. The line of decisions, including the decision in Gurshinder Singh, Supra, emphasize the fact that the mere delay in informing the insurance company of the theft would not be a justification for the insurance company to repudiate the claim. In the present case, admittedly, the intimation was given to the insurance company on 5th February 2010. That is about 6 days after the alleged theft, after the incident of theft of the vehicle. That is on 31st January 2010. Paragraph. The court has today been shown a copy of the order passed. That's it. Order passed by the SDJ in Bhubaneswar on 15th December 2011 in GR number 549 of 2010, accepting the final report submitted by the police under section 173 CRPC in relation to the FIR number 50 dated 22nd February 2010 concerning this very incident. The conclusion in the said report of the police is that the investigating officer, open quotation, could not find any clue regarding the culprits as well as the stolen vehicle. Unquote. In other words, the report of the police is not that the FIR itself is not a genuine one, or that the complaint was false. Paragraph. It must be stated that an averment to this effect has indeed been made in the writ petition in para 2 bracket 6 of the writ petition. For some reason, however, a copy of this, of the final form, was not made available to the Ombudsman before passing of the impugned order dated 10th April 2013. Paragraph. Be that as it may, it appears that the circumstances under which the vehicle went missing, as pointed out by the driver petitioner, appears to be a genuine one. And there was no justification for the insurance company to have repudiated the claim only on the ground of delay in information about the same. Delay of about 6 days of information of the same to the insurance company. Paragraph. Although the FIR may have not been launched, open quotation, immediately, unquote, the final form shows that the complaint was not a collusive or a false one. In the circumstances, the impugned order dated 10th April 2013 is hereby set aside. The insurance company is directed to process the claim of the petitioner now and settle it in accordance with its policy, not later than 4 weeks from today.
The Lordship, 6 weeks from now, I'll get the certified copy.
Oh. Okay. Certified copy of what?
This order they have to produce because they have to process it, obtain approval.
So you can get a downloaded copy of this order. You don't need a certified copy. The insurance company is directed to act on a downloaded copy of this order.
Yes, done.
Right.
Vehicle list item number 14.
My item is the second item. With regard to fixing the headquarter of Tahsil. Page 10, Annex 1, may I take notes? Second item is mine. WPC number 10942.
Sorry? 10942.
Mela.
Connected item.
Jisaya Gomango.
10942.
Yes.
Last time they are allowed to get the.
Lordship, see the last order, my lord. Lordship, I directed the petitioner as well as the State Council to take instruction about the present status. The 3 cases are there. My learned senior is appearing in a case which is of the year 2012.
I know too.
Other 2 cases are 2013 and 15. We have filed counter in this 3rd case, my lord. Lordship, kindly take up 3141. That will suffice, my lord, everything.
Yes.
This is the case regarding fixation of headquarters of the Tahsil office. If your lordship takes up the case of my learned senior, my lord, that is WPC 10942. Here the prayer is, my lord, to quash annexure 4. That is the communication dated 10/5/2012. Page 22.
In my case, there is a stay order. That is, I am the contesting party in this case. And they have filed the counter in this case also. So, my lord, it may be taken up. This case is the second item, 10942.
Yes.
But in this case, may I take your lordship to page 10, annexure 1. That the reorganization of Tahsil office in the state occurred, Miller. And this new Tahsil is created at Nuagadh in the district of Gajapati. And the headquarters is fixed at Nuagadh itself, bearing the name of the Tahsil. But after 4 years, they have changed this site, saying that it will be, the headquarters will be situated at Dogharia, changing the name of Nuagadh. That's why I am aggrieved by that.
Yes. What is the grievance?
The grievance is the headquarters of the Tahsil should be bearing the name of the Tahsil, that's Nuagadh, at Nuagadh, because we have the land, we have the property, and government lands are available there, and they, without consulting the local representatives, they, with motivated action, they have shifted it.
What is motivated? What are you losing because of that? What are you losing because of that?
Because of we are the main place that centrally located. The Nuagadh is centrally located. For that, the name of the Tahsil is named as Nuagadh. And what is the reason to change it to another place after 4 years? That's a political bias that we have challenged. And to that, Milord, I have the answer.
It's political bias. What is the counter say? What do they say in the counter affidavit? Let's read that.
The counter has not been filed in that case.
No, you are filed.
Filed.
And the site selection committee, Mr. Mahanti, the site selection committee who is empowered to choose the site for the headquarters. They have selected Dogharia as the headquarters.
They are not empowered, Milord. That is the decision by this honorable court, Milord. I am passing here. Milord, just have a glance. There's a high power committee is being set up. So that is not high power committee. The collector himself, collector and ADM, they have selected it.
You come to the counter affidavit.
Yes. And there is a decision.
Come to the counter affidavit, sir.
Well, counter, the last counter they have filed by the government. That is payment I have not done. Counter affidavit by Sachidanand Mr. the Deputy Secretary.
Page 48. Running page 48.
48.
This is another counter.
State.
There's also another counter by the Tahsil Director.
Para 8 minutes. By the revenue department, that is by the government, the counter is filed. One is by the collector, another is by the government, and the latest is the government counter. That may be reported.
Come to para 6, sir, first.
Para 6. Miller, the reply to the government at para 2 of the petition, it is only submitted that the petitioners who were villagers of Nuagadh have submitted a representative address to Chief Minister of Orissa, which was received on 2/2/2011, and a letter of the Honorable MP Barampur has also been received on with a request to open the Tahsil office at Khajuripada instead of Nuagadh in the district of Gajapati for larger interest of the public. In view of conflicting demands, as regards fixing the headquarters of Nuagadh Tahsil, either at Nuagada and Khojipada, having been received in the shape of representation from various parties, the views of the collector Gajapati Barampur and the recommendations of the member board of review have been sought for taking a final decision thereon by government letter so and so, addressed to the collector Gajapati, addressed to so and so. In reply to the amendments at paragraph 3, the representation, it is humbly submitted that the decision on the location of the headquarters of new Tahsil is prerogative of the executive. In reply to the amendments at paragraph 4 of the read petition, it is humbly submitted that after considering the representation received as well as the reports of the collector, Gajapati, RDC Barampur and member board of revenue, the matter was processed for obtaining government order. Government have decided to fix the headquarters of Nuagada Tahsil office at Dogharia instead of Nuagada by government notification so and so by 10/5/2012, modifying the earlier notification 6/8/2008. The collector Gajapati has submitted his report that the headquarters of Nuagada is in Nuagada. The distance from Dogharia to Nuagada is 5 kilometers. As there is no government land available near the block office, and the land available is about 2 kilometers away and is not connected by road, the site selection committee and the collector Gajapati proposed Dogharia as the location for the new Tahsil office, and it was found more appropriate to locate the headquarters.
You have not filed any rejoinder to this. There's a genuine reason, sir. You have not filed any rejoinder.
It is Mavit area. I have been contacted today.
No. How many years ago was it filed?
No, I have answered.
This is 13, filed in 2013, sir.
My lord, for this, how they have misled, by the report they have misled. They have given a plot number of Dogharia and they have given the plot number of Nuagada. So this map I have brought me. Just have a glance.
5 kilometers away, sir. How are you?
No, that is not 5 kilometers away. It is close to the road. Just have a glance. I'm passing on. These are the.
How you are agreed, Mr. Mark? How you are agreed?
Agreed, we are the Nuagada is the Tahsil. They are the block office, but they are shifting it to another village.
No. Your case is because it's a Nuagada Tahsil. It should be at Nuagada.
It is their location is fixed. Nuagada location is fixed by the government. But what is the situation arose?
They have reviewed and changed it.
The review is what? The review is my allegation. The review is malified because and what they say.
One minute. You can make any allegation you want. The fact remains this affidavit was filed in 2013. Today we are in 2022, 9 years. Orally arguing that something is malafide will not be taken.
No, really. I'm passing on some documents.
Sir, passing on documents, please understand.
No, it is the map. It is the document.
1 minute, sir. You have made an allegation. It is malafide. Malafide is not to be made so lightly. Malafide has some connotation in law. If you do not even file an affidavit alleging malafide, the court is not bound to take note of such submissions.
In affidavit also, in my read petition that I have
challenged
by saying that no local representative is consulted.
So you don't even allow the judge to complete the sentence. This is remarkable. Remarkable. This is the style of advocacy.
No, I'm illustrating my point.
You have to make your point irrespective of what the judge says.
No, my lord, I'm sorry.
Sorry is so casual. No. You're not really sorry.
Sorry.
You're not sorry. You're saying sorry because you have to say sorry.
No, my lord, this is the judgment by this.
What is the law relating malafides? What is the law relating to malafides? Are you aware of that?
That is very much aware of this. Huh? I have also taken that point also.
No. What is the law? What is the law related to malafide?
To whom, against whom we have to...
you know there are two concepts, malice in fact, malice in law. Do you know the case law? Are you aware of the judgments of the Supreme Court on the subject, sir?
If the malafide, this is a political bias. Basically, it's a political bias.
Sir, the more and more you keep adding phrases like this, I'm going to ask you for case law. Better be careful in how you make your submissions. What is the case law on this? What is the case law regarding malice in law, malice in fact? What are the judgments of the Supreme Court? What should you say in your pleadings? What are the judgments on that? You're in a 226 before this court, sir. What is the law? You have to educate us.
It is the case is I have made the averment.
What is the case law, sir? Making averments is the simplest thing. You sit in your table, you dictate averment, and it is typed. Some client signs the affidavit, it is filed. That's the easiest part. Easiest part is simply saying something is mala fide.
Well, there is a decision.
The most difficult part is how do you establish the mala fide?
There is a decision by this honorable court. There is a reporting decision by this honorable court on this subject that I relied upon. How the headquarter of a tahsil could be fixed up. That is a decision by this honorable court.
Sir, my question to you is something else.
I understand.
You are answering something else.
With regard to Malafide, my lord, what is the case laws and all that? So, if my lord on that point, I'll get.
We are not adjourning. We are not adjourning. It's only this case was filed in 2012. One case was filed in 12. One case in 2013. Third case in 2015. Well, we are in 2022. Is there any justification just because some Tahsil headquarters is shifted by 5 kilometers, you have a status quo and you're sitting on it for 9 years?
But what logic they have advanced? To that I am answering.
Yes.
They have merely said it is the report they have prepared. It is only their report, and that report is itself misleading. That document I am submitting before my lord. And there is a decision on the subject by this honorable court.
Show us.
এটা দেখো না, এটা দেখো ও সিএলটি 2014 117584 দেখো 117 2014 CMT 584.
Yes.
No.
Yes. Yes, sir. So what do you say?
Well, this may be referred to the high level committee.
So there's already a committee. So site selection committee went.
Committee,
Yes.
my lord, just have a glance. What is the committee about page 21 of my writ application? Page 21.
So you have not filed a rejoinder to this counter affidavit at all. Why should we not go by what is said in the counter affidavit?
And in this
counter affidavit is filed in 2013.
In their counter affidavit,
we are in 2022.
They have also stated this is confusing. Someone said it is Khajurpada or Nuagar or then Dogari.
Para 8 is no confusion.
So
at
in
all.
this confusing state
You
of
just
affairs, high level committees.
There is no confusion. Sir, come to para 8 of the counter affidavit.
Parade. The distance from Dogaria to Nuagada is 5 kilometers, as there is no government land. But there is a government land very much available in Nuagada.
No, we can't, sir. We can't. There's no rejoinder to this. We are not going to disbelieve the government when it says this.
In this, it is a Maohit area. The people are they are also afraid of coming here. So in that event, if fairly for a long time in this stage operating, and in this situation, if a high level committee is given a time to decide within a fortnight or within a month, it can be decided.
Anything else, sir? One minute. Issue involved in the present petition concerns the correctness of the decision of the government of Orissa manifested in a decision in the order dated 10th May 2012 of the Revenue and Disaster Management Department, ordering that the headquarters of the Nuagat Tehsil office will be at Dogaria instead of Nuagat. Paragraph. The 11 petitioners, who are all residents of Gram Panchayat
9 Gram Panchayat
Nuagada in Gajapati district, are aggrieved by the above decision. On the ground that the decision to shift the headquarters to Dogaria was without any inquiry and without consulting the petitioners. And that this was taken only to no, this was taken without addressing the genuine interests of the residents at Nuagada. Full stop. Two counter affidavits have been filed. You say, while issuing notice in the present petition on 30th June 2012, This court directed that status quo shall be maintained. That interim order has continued for almost 10 years now. Paragraph. In response to the writ petition, 2 affidavits have been filed. To stop. The first is by the Deputy Collector, Gajapati, on 27th August 2012. Placing on record the proceedings of the Single Court Site Selection Committee. When the question arose as to the construction of Tehsil office buildings and staff quarters, the Tehsildar had submitted 3 alternative sites with selection proposals, that is Novagada, Khajuripada, and Dogriya. Stop. The site selection committee met on 23rd April 2011 under the chairmanship of the Collector Gajapati, where it was resolved that the proposed site at Dogriya shall be selected and accepted. After considering the most suitable and available of each communication facility and availability of government land for construction of Tehsil office and buildings. Full stop. Another counter affidavit has been filed by the Undersecretary of the Revenue and Disaster Management Department, where it is pointed out that while the petitioner submitted a representation on 2nd December 2011 asking that the headquarters be continued at Novagada, the MP at Berhampur made a representation on 15th April 2011 with a request to open the Tehsil office at Khajuripada. Full stop. It's pointed out that after considering the representations as well as the reports of the Collector Gajapati, the RDC (SD) and Member Board of Revenue, the government decided to fix the headquarters at Dogriya by the impugn notification. So it is pointed out that, open quotation, the Collector Gajapati has submitted his report, take from top of page 15 up to the end of that paragraph 8, that is Novagada, Tehsil at Dogriya, the whole of para 8. Unquote. Paragraph. Despite the above counter affidavits having been filed more than 9 years ago, no rejoinder affidavit has been filed till date by the petitioner. Paragraph. Mr. Srinivas Mantri, learned counsel appearing for the petitioner, placed reliance on the decision in Sarat Kumar Raj versus State of Orissa 117-2014 CLT 584 to urge that the impugned decision to shift the Tehsil headquarters to Dogriya must be quashed with this court, must be set aside with this court. Paragraph. The court has carefully perused the above decision, which appears to have turned on its own facts. As noted by this court in the said decision, there were 2 conflicting reports of the collectors as regards the location of the Tehsil headquarters. At one point in time, there is a report of the collector cum district magistrate Baleshwar to create the Tehsil headquarters at Bahanaga. At a later point in time, when another collector joined, he gave a contrary report. Noting that, open quotation, both the reports of the collector cum district magistrate Baleshwar are diametrically opposite and inconsistent, unquote. The court ordered a high-level committee to be constituted to re-examine the whole issue. Paragraph. On the basis of above decision, Mr. Mohanty argues that even in this case, a high-level committee must be established to examine the issue. Full stop. The court is unable to agree with the above submission. Full stop. As rightly pointed out in Sarath Kumar Raj versus State of Orissa Supra, after analyzing a number of decisions in the Supreme Court, in matters of policy, the court should be slow to interfere. Full stop. The court, in that case, concluded, open quotation, the court cannot strike down a policy decision taken by the state government merely because it feels under the policy, let's say A to A. In the present case, the petitioners have been unable to show in what manner the impugned decision to shift the Tehsil headquarters to Dogaria from Novapada could be said to be arbitrary, patently arbitrary, discriminatory, or malafide. Full stop. On the contrary, the counter-affidavit points out that the new location is just about 5 kilometers from Noagada, and that there's insufficient land available in Noagada for constructing a Tehsil office as well as staff quarters. That view of the matter, the court is not inclined to interfere with the impugned order dated 10th May 2012, shifting the headquarters of the Tehsil from Noagad to Dogaria. The interim order is vacated, the writ petition is dismissed, but no order is to pass. So the other matter, 3141, you are not there, sir?
No.
All right. Who is appearing in those matters?
They are opposed to me. They wanted to vacate the stay order.
Oh, I see.
So they maybe they decided.
Right. In view of the order passed today in writ petition civil 10942 of 2012, these writ petitions do not survive and are disposed of as such.
Both the first one and the third one.
Yes, counter has been filed in 3141.
All right.
First one also.
I'm sorry, Manoj.
First item.
First is Manoj 4705.
That is also.
Yes, that is also there. Both the petitions are same. They are challenging the shifting from Dogaria to another place. Now it has been shifted to third place.
So in
Khajurpada.
Disposed of. Correct.
Wiki list item number 15.
May I please? Like this matter is relating to water conservation fund, which your lordships have already decided. I've given your lordships to order of your. That your lordship said it's a request, not a coercive action.
Correct.
If lordships permit me, I have got a copy of your that slightly corrected of the dates, because the dates will vary. That case and this case, the dates will vary. I've given a corrected dates.
All right.
Even in the connected matter, Milord, I've taken the liberty of.
Yes. All right. Just pass the same orders with the change dates. All right.
Grateful.
Wiki list item 16.
Wait till option. Here is a case not where there was a prayer to declare Salehpur as a notified area council.
Right.
Under Article 243Q of the Millar Constitution.
Right.
Read with Section 4, subsection 2 of the Orissa Municipal Act.
To notice, we have filed the counter affidavit in the year 2017. Now, in the meantime, more than 4 and 5 years have elapsed.
Right.
So, Lords may grant some time. I will obtain.
No, from their own counter, I'll state one sentence, Malad. That will be enough to dispose of the matter, Malad. The counter has been filed by the opposite parties 1 and 2, but not by the collector 3, Malad. The entire responsibility has been shifted by the opposite parties 1 and 2 to 3, Malad. That though there has been recommendations and there has been notification as required in the Gazette, the collector is sitting over the matter. He is not forwarding the file. That is the counter. Lordship, kindly see the counter affidavit.
No, so he's saying he'll file a fresh affidavit.
That affidavit was filed in the year 2017.
But it could not be taken up because of the ensuing election, Malad, then.
and then it could not be taken up. That is the only thing. Lordship,
Let
just
them
seize.
file a fresh affidavit. Let them file a fresh affidavit stating the facts.
Yes. Well, I had filed also the rejoinder also. Let the counter be filed by all the opposite
The main
parties.
prayer in the petition is for a direction to the opposite parties to notify, to declare Salipur as a notified area council. Full stop. Mr. Mudli states that although the earlier replies were filed way back in 17, which is more than 5 years ago, there is need to update the current status, and therefore he may be permitted to file an additional counter affidavit, a supplementary counter affidavit. Sir.
Yes.
The supplementary counter affidavit be filed not later than 25th July 2022 with an advance copy to constitute the petitioner. He is permitted to file a rejoinder thereto for the next 3rd August.
Quick list item 17.
May I please, Lordship? Lordship, we have filed 2 additional affidavit, Lordship. This is a kind of mercy petition, Lordship. I have my land at the coast of Chilka, Lordship. I have given undertaking that I will not do any aquaculture. My coconut trees are there on the dike, and I have dried up the pond, Lordship.
You've also filed a writ petition.
Lordship?
Have you also filed a writ petition?
No, I have not filed the writ petition.
No, but we're all permitted to have agitated separately. No?
Yes.
We had permitted everyone to agitate it separately. Instead of filing more and more IAs.
Lordship, in this case, what happened? Your Lordship on 4th May order, first an order to the effect that they will file the counter in my IA. What happened? Without filing the counter, Lordship, their JCPs are there at my land, Lordship. I am having more than 100 number of coconut trees. 2 of the farmers are there. This is the 2 IA only, 18110 and 18296. These 2 person, Lordship, your Lordship have a glance to the additional affidavit which I have filed, that backside of that where I have this coconut trees, Lordship. I am a farmer. I don't have any other sources of living. I will not do, I have given the undertaking that I will not do any kind of aquaculture, Lordship. It is just at the coast of Chilka. That's my livelihood, Lordship. I have a house also. I am staying there. 2 of the farmers, they are staying there. They have their house. And there is no water in one of the, that is 18110. The other one is, Lordship, the Chilka water is entering to my land because it is recorded land. So if they want also, I can pump out that water also. I will keep the land completely dried, Lordship.
No, but if you're only having coconut trees,
Lordship,
if you're not doing any prawn or fish, what have you to worry about?
Yes.
Nothing.
Lordship, I am fearing to them, Lordship, in another IA, Lordship have a glance.
So when they come
in
to
another IA, what happened? They have demolished my pond and they sent post the notice only 7 days back. 13647, Lordship.
1 minute, sir. If in your land there's only coconut trees, you say, right?
Lordship.
What will they demolish?
Lordship, the Tahsildar Chilka, very often they are visiting to that. They are telling that you dried up that pond.
No, you said there are only coconut trees.
Yes, Lordship, coconut trees. Suppose what dike is there on the dike, Lordship, coconut trees are there. That only be protected, Lordship. I will not do.
No.
And also in future
you
also,
say the Tahsildar will come and cut your coconut trees.
Lordship, that finding may the Lordship.
Finding? What finding?
Will not, Lordship, we are in apprehension, Lordship. The way they are,
should
Lordship,
we say when the collector comes to your land, finds there is no prawn cultivation happening,
no aquaculture even, Lordship. I have given
so
that
once he finds there is no prawn culture, no aquaculture, no culture, nothing,
Lordship,
he should not cut your coconut trees. This is what we should say.
Your Lordship, that's your order. Your Lordship order can say me, Lordship. In what happened?
We should say that.
Lordship, in
that the collector should not cut coconut trees.
Lordship, in Kumandal areas, their IA is pending. They have demolished 100 number of the trees which is supposed to be burned by the local people, Lordship. They have demolished, and high-handedly the person, those who have that JCP, they have taken that woods, Lordship. That is
we stick to your petition, your application.
Lordship, I am confining to my petition. I have in a mercy petition before Lordship.
Where's the mercy? if you're not having any prawn cultivation at all, why do you need
I'm a
nursery?
poor man, poor farmer. I have only these two farmers.
No, there's a question of, I don't understand. If you're not having any prawn culture, why should you be afraid of anything?
Lordship, because your Lordship's order is there from the high tide line 200 meters. So I am in apprehension because my land is just annexing to Chilka Lake, Lordship. And I have put the dike for not entering that Chilka.
So what your apprehension is? That's the main question.
Lordship, they are not demolishing my coconut trees, Lordship. I am safe.
So we can only say if the collector finds only coconut trees, he should not cut coconut trees.
Lordship, that's only that's petition before my.
You're not serious, sir. You're not telling us the truth. That's the whole.
No, Lordship, I am in the
Lordship petition before Lordship, which is why you're in trouble now.
No, Lordship,
there's no need to file this IA. If you had only coconut trees in your farm, why do you have to file an IA?
Lordship, the coconut trees, I have done these because the coconut trees cannot grow in the water, Lordship. It is required to be in the some portion of the land to be make height, Lordship. Because what happening in June, July, when the water in the month of June, July, when the rain is there, then the Chilka water in natural process they pumped into my pond, Lordship, my land, Lordship. In that process, what is happening? We have put some because that land is completely not suitable for paddy cultivation, Lordship. Your Lordship is fully.
No, you see, your point is that you are not making any aquaculture. You have no connection with prawn culture.
Lordship.
You are having only coconut trees.
Lordship, coconut
and
trees.
in the guise of this order, now Tahsildar is going to demolish.
Lordship, let the Tahsildar give a affidavit to that effect, visiting to the spot that if I have my coconut trees, they will not touch my.
What is the cause of your apprehension, Mr.?
Lordship, the way they are terrorizing to the farmers of the people across Chilka, particularly some recorded tenants, those who cannot do any other things except this. That is my apprehension, Lordship.
If they do, you then come.
Lordship, this matter is to be. Lordship, this matter is supposed to be addressed. My learned senior Dr. Adi Sagarwal. Perhaps I am not getting his linkage. He's in line. Perhaps
you arguing
I'm sorry.
For half an hour.
No, Lordship, because he is supposed to.
No, you are arguing very well.
I'm extremely sorry. I'm in I was traveling. I was in train. I missed my train last night. I would have been. So I'm not in. So only if they should not remove these trees.
Coconut
only
trees.
That is. Yeah, coconut trees. That should be. We are not doing. If we are doing, they can demolish anything. If they found that we are doing aquaculture, etc. Only I've been briefed that earlier they were earlier, but now they changed their, once this is a clear law, Lordship has settled it, that nothing will be allowed. So they are not doing.
Dr. Agarwala, the point is this. We will record your submission that there are no aquaculture farms, there's only coconut tree.
Yeah, earlier they may be having, and now they don't, because once Lordship has made it very clear, it will be not allowed. So they are going with it that they are not to do. Only this coconut tree should not be removed or spoiled.
I don't know. Is the collector in Puri and Ganjam and all busy collecting coconut trees?
Lordship, this is under collector Khurda, Lordship.
So all these collectors are busy going chopping coconut trees.
They may. That's why we are.
Let us be serious, sir. We are on shrimp farms, illegal shrimp farms, in the guise of the guise of demolishing shrimp farms. From what you say, in the guise of demolishing shrimp farms, the collectors in these districts are all cutting coconut trees.
They are.
Please let us be more serious, sir. I think we should be more serious in our submissions.
Only they are now. They will not do this aquaculture because once Honorable Lordship has made it very clear. So everybody is duty bound. That's why they want to do only this thing. This coconut, these trees should remain. And other thing, when they are not doing this aquaculture.
All right, sir. All right. Both these petition applications 18110, 18296 of 2021. the repeated assertions by Dr. Adish Agarwala, Learned Senior Counsel, and Mr.
Akshay Mishra,
Learned Counsel for the applicants, is that there are no aquaculture farms, no illegal prawn culture activity being carried out in the lands in question, and that there are only coconut trees and nothing else on the lands in question. In the circumstances, the court sees no reason for any apprehension that the local administration is, as is being projected, going to cut these coconut trees in the guise of enforcing the orders of this court. It is, however, made clear that if on these lands in question, the local administration finds that there is any illegal activity as directed by this court, they will be free to demolish all illegal aquaculture and prawn culture farms that may be found in the lands in question. The applications are disposed of.
Yeah, highly obliged, my lord. Highly obliged, my lord.
Item 18, I am a BC man.
Yes.
Lord, though the matter is regarding the service matter, but the short point for consideration would be with regard to catch-up rules. Catch-up rules, Lord, the promotions that have taken place, petitioner.
This will take some time, sir.
Obviously, Lord, it will take little time.
Yeah, we'll have to have it on some other day because 2 o'clock there's a reference.
In terms of your Lordship's convenience, my Lord.
Correct. You say list on 29th August. Right.
This is the PIL regarding health matter.
What's the current position, sir? Tell us.
Yes. Pursuant to Lordship's direction, my lord, we had filed an affidavit on 14/12/2021. Then before that, your Lordship had directed us to furnish the data regarding the sanction.
Tell us to prepare notes on this PI. There is a note on this PI. That won't help us. Where is the hard copy of the notes? Yes, sir. Tell us.
Yes. Lordship had directed us by order dated 17/11/2021 to furnish the data regarding the sanction and working strength of government doctors district-wise and specialty-wise. That affidavit was filed on 14/12/2021. Thereafter, through the pen drive, Lordship had directed the registry to provide us all the records. I'm sure my learned senior we have also received it. We have sent it to the government to give necessary instructions about that. That has not come. I'm only praying, my lord, in the reopening week, Lordship may kindly keep it.
See, these are serious matters.
Yes,
a lot of work has happened. Our DLSAs have gone to every facility, done a detailed note.
They have furnished reports also.
My lord, the report says 2 common things. That is lack of doctors and staff and urinal. Urinal. They are common in all districts, even PSCs.
Okay.
And some PSCs are locked. So what government will give instruction? Right to treatment is a right to life, as your Lordship observes.
Although I'm not equipped with any instructions from the government, my lord,
and
if a Lordship passes in order to implement certain things, my lord, we'll do it by next year, my lord.
Yes.
After vacation, Lordship will fix it to the reopening week. Within that
period, we lose a lot of time. See, the point is this.
My lord.
Again, at that reopening, you will again ask for time to file a reply only.
Yes.
Then we'll be nowhere.
May I pray, my lord? We'll prepare and file the reply by the reopening week. In the meantime, Lordship directs to implement anything, my lord, will abide by Lordship's order.
Sanction post.
Filling up posts. What is the action being taken for filling up posts? This has been that's how this whole PIL itself started. And our orders also was on the same effect.
A 3-page affidavit we have filed, wherein your Lordship, pursuant to Lordship direction, we have given the data about the sanctioned post and the vacant post. That is affidavit dated 14/12/2021.
Just come to 17 November 2021 order.
My lord. My lord, first issue and second issue, my lord. Thereafter, Lordship gave a direction to the district level officer.
And pursuant to this, they prepared those reports. And these reports were submitted to you in December itself.
Yes, my lord.
You had December vacations, and then in between these vacations, between January and today,
no, that
is enough time.
With due respect, my lord, Lordship may kindly see the last order 9/2/2022. Though the registry was directed to give a copies of the report, it was belated, so we got it at a later stage, my lord. Lordship may kindly see 9/2/2022.
Yes. So you got it on 9/2 at least?
No, my lord, we got it, yes.
So 9/2 is for 3 months ago.
May I pray, my lord? Lordship has keep it to the reopening week. In the meantime, Lordship directors to
would have lost 6 months in the bargain.
My lord, I'm sorry, my lord.
The whole effort is going waste, sir.
My lord.
See, 21st or Saturday, we are having some another matter, right, on prisons. We can have this on the same day.
Yes, my lord.
Because the detailed directions will have to be issued.
Yes, ma'am.
You better have your instructions ready by then, sir.
Yes, ma'am. 21st, your lordship.
Saturday, we are hearing the prisons matter. We'll take up this also.
Yes, ma'am.
You see, list on 21st May 2022, by which date the Council for the State will have detailed instructions on the reports submitted by the secretaries of the various DLSs. Right.
The other PIL regarding vending zone or that medical road related.
Sorry, sir.
That's another connected matter. Whereas the issue is with regard to vending zone, that is to be addressed by the CMC.
But in both front of the medical gate.
We can take up both on that day.
Yes,
yes. Right. Yes. Right. Mr. Mishra is there on the, you have to permit him to.
My lordship, the matter is alienation of mutual land in favor of a company, which is contrary to various judgments of the Supreme Court, my lordship, and I have mentioned all these judgments in phase 2 in my rejoinder, my lordship, in preliminary submission. And those orders have also been circulated by the government of India to the chief secretaries. Phase 2, my lordship, of my rejoinder, my lordship. Phase 2.
Yes.
This order, my lordship, civil appeal number 436 of 2011, arising out of SLPC number 2203 of 2007, State of Jharkhand and others, versus Pakur Jagran Manch and others in the state of Jharkhand. In this matter, my lordship, this order has also been communicated to various chief secretaries by the government of India by Annexure 2 of my rejoinder, my lordship. Annexure 2.
Yes.
Page 16, my lordship. And my lordship, alienation of mutual land has been restricted to only public purposes. Only public purposes, my lordship. Annexure 2, my lordship, page 16.
Yes.
Sir, with reference to the caption subject, I am directed to bring it to your kind notice. The judgment dated 12th January 2011 of Honorable Supreme Court in the matter titled State of Jharkhand and others versus Pakur Jagran Manch and others, civil appeal number 436 of 2011, copy enclosed. My lordship, I am just reading para 15 of the judgment, and that is there in page 17, my lordship.
Mr. Mishra,
my lordship.
Today we have a special reference at 2 o'clock, so the court will not continue.
My lordship.
This will take some time, so we'll have it on some other day.
My lordship, immediately after the puja vacation.
All right. All right.
No problem.
List on 23rd June, sir. 23rd.
Obliged.
List item 21.
I am for the petitioner, my lord. Here is a PIL seeking for a direction to the state for providing all benefits to the under the rehabilitation program to the petitioners, my lord. They are land ousties in view of the acquisition of their land for the purpose of Kanupur irrigation project, my lord. So your lordship on the date of issuance of notice has directed the state to take obstruction and report compliance.
We have asked for the instructions, madam. Lordship may grant us one last chance. We'll file the counter. In case of 2021.
A last opportunity is granted to the state to file a supply within 8 weeks. We joined up for the next date. July.
List item 22.
My lord, in this case, we have already filed our counter.
No, my lord. In last occasion, they paid for.
Just a minute. I have already filed in online, my lord, on Friday. And inadvertently, I have also filed miscase that is only for the opposite party number 2 to 4 will be changed, substituted by the present scenario. That is also. Thereafter, you say.
If my friend is submitting such, lordship may kindly have a glance to IA number 6227 of 2022 at flag K. I have annexed that document. I have also annexed.
May I submit, my lord?
Yes.
May I audible? May I audible, my lord?
Yes, please.
My lord, in this case, what I am submitting, my lord, last occasion, however, appearing and matter is going on, it is very unfortunate that somebody has entered in this system and they are not showing his face. Then he has alleged ourselves, officials and court also. And direction was given that who is the person who is appearing with the court, even though so his face, he has started abusing the process of the court, allows the law officers of the court. So in this incident, my lord directed 50, when the court wants, who are you? He replied that I am opposite partner. 15 is completely wrong. The 15 is appear before court by filing affidavit. He is not entered in the on the system, my lord. So my humble request to my lord that inquiry may be made in this regard. Who is the person? Unauthorized, they are appearing in the court. They are alleging against us. And these things are today, one court has assaulted, another day, another court will assault. They are alleging us also, they are alleging officials also. It's very unfortunate system. My lord, this when I contacted the authority concerned, they told that we don't know who is the person, who are the petitioners.
No, what is the long and short of all this?
The case.
I may pardon, my lord. On that day, my lord, I am the OP 15, my lord. I am on the duty, my lord. I have never opened the virtual mode and never say anything, my lord.
1 minute, sir. Permit. Whom are you appearing for, sir?
I am for the petition.
My lord, I am for the Union of India with
CGC.
You are with Mr. Pari.
My lord.
You have filed an affidavit.
My lord.
When?
On Friday, my lord. Online, I have filed it.
All right. Counsel appearing for the Union of India states that he has filed his affidavit on Friday is what date? 14th. 13th. On 13th May 2022. Rejoined. You've got a copy, sir?
No, my lord.
Copies thereof we served and counsel for the petition.
Only limited submission, my lord. The matter will become infectious on 1st of June, for which I have filed the IA on 9th of May, giving the details. I am supplying the copy, my lord, of the annexure. Previously also I have filed another notification to which the other bench of this court had take care of and not allowed them to file any affidavit or counter affidavit. This matter will become totally infructuous because it will be, I have only one copy, my lord, because I supplied to my friend was not having, his copy was missing.
Sir, many of you just don't make copies of anything. There are either no copies for the court or no copies for your other side.
I have supplied in the IA.
So we'll look at the IA then. Just give it back.
IA at flag K.
All right.
Flag K.
What are your instructions on this? What are your instructions, sir? What are your instructions on this?
On this change settlement, we have also filed an IA to substitute opposite party number 2 to 4, my lord.
By what?
Because in the circumstances, the now due to this board and by total 41.
What is your IA?
In fact, my lord,
my IA is inadvertently not on 13th, but today I have filed by the online matter. That is my.
The fact remains like this, my lord.
1 minute, let us see what this IA is. Amendment of cost citing. Transfer is section 1st October. We given him a copy.
Just before entry to the, I have asked for this. They also will argue the case for final argument. You are.
Sir, I'm just asking a simple question. Have you given him a copy of this application or you have not given him?
My lord?
ଆପଣ କପି ଦେଇଛନ୍ତି ଅଦର ସାଇଡ କୁ ସେଇଟା ସାର୍ ପଚାରୁଛନ୍ତି କୋର୍ଟ ପଚାରୁଛନ୍ତି
ହଁ ନାଇଁ ମୁଁ ତାଙ୍କୁ ଫାର୍ଷ୍ଟ ଆୱାରରେ ତାଙ୍କୁ କହିଲି ଯେ ମୁଁ ଏଇ ଦିଟା ଫାଇଲ କରିଛି କପି ଦେବା ପାଇଁ କହିଲେ ମୁଁ ଆଇ ୱିଲ୍ ଆର୍ଗ୍ୟୁ ଦି ମ୍ୟାଟର ଫର ଫାଇନାଲ ହିୟରିଂ ଡିସ୍ପୋଜାଲ
Application has to do with your prayer only, sir. You better take a copy of this application. If you refuse to receive a copy of the application.
No, my lord. He has not refused. He will tell that I will.
He has not. He told I am filing today, but he has not served copy on me.
Yes, I am saying that.
He told I am not doing
You are not
Xerox.
making a correct submission.
My lord.
You are not making a correct submission. You
No,
are not offering
never.
a copy.
Sorry.
No, my lord.
I don't expect such kind of submission.
No, I am not blaming on the first. My learned senior will admit that. I am saying that I am filing
today
counter on 13
to him or not.
Yes, I will ask I will serve the copy and I will mention.
Why do then make a submission not correct?
No, I am not telling that he has refused, my lord. I am not telling so. I am only intimate that I am filing today and I will ask for that. This is the situation. I will in course of the day I am serving. Let another day may let it come.
Mr. Pati, Learned Counsel for the Union of India further states that he has today filed an application substituting opposite party numbers 2 to 4. Copy of the said application be served on counsel for the petitioner today itself. Let's 6th July. Right.
Weekly list item 23.
May please, let's see.
Oh, 1 second, my lord. What I pray, I have only 3 days in my hand.
That's not true at all, sir. That's why you have to read that application. All this changes happened in October itself.
No, it is changing on 1st of June.
From his application, it appears the change has already happened.
I may pardon my
Take
lord.
a copy of that application.
I may pardon my lord. I have also filed affidavit, my lord. I am OP number 15, my lord.
You file it in the registry, sir.
My lord, it will become infectious. My 100%.
You first read that application, sir. You will know what has already happened. Yes.
Lordship may keep it to tomorrow.
No. Yes.
I may pray, my lord. My personal paper is there, my lord. Kindly glance at 25th, 422, my lord.
So we'll deal with all this in the next date. Yes.
May I please, Your
Item
Lordship?
28.
Your Lordships, in this matter, the present petitioner is the legal heir of the original assessee and filing the return in regularly, but he is unable to take the refund because of the non-incorporation of the
Now
bank
they filed a
details.
reply. Or
Yes,
no
Your
notice.
Lordship.
Notice
Yes.
is not gone. There are so many defects, madam.
Only, Your Lordship, that defect is because of this.
You remove the defect. You remove the defect.
Not that is not legible, but
Whatever. The defects we removed.
only, Your Lordship, the
Already
page 19 is important.
All
yes,
right.
only ITO is.
You're not filing a reply, Mr. Chimanka.
Only one direction, 19, page 19. He has to file an application before the concerned ITO and
Yes,
ITO.
Lordship. Only ITO will incorporate the bank details. I will approach the ITO.
Also, the petitioner states that she will approach the ITO concerned with the necessary bank details. If the application is filed by the petitioner for the ITO not later than 4th July 2022, it shall be processed and an appropriate orders issued thereon within 4 weeks thereafter. No further directions are called for the petitions disposed of.
Oh, bless.
Weekly list for hearing item 24.
My lords, in the last occasion, your lordships have prayed for at least 3 cases. The records are not available, but I have filed a note on the entire 5 cases. And there is a judgment of your lordship's court on Robinson Barley, which I am challenging. But I would pray for a larger bench for the reason that your lordship has followed a judgment of 2-judge bench of the Supreme Court in 1993, where in the case of Rajasthan roller.
Sir, today we will not be able to hear this because of the reference at 2 o'clock.
Yes, my lord. Your lordship to put it to opening day.
Or at least on 20th June. All right.
Great.
Weekly list item 25.
Lordship, can you see the last order?
I am submitting, my lord, the file in seal.
25.
Hearing may take some time, or you also may kindly fix a date because they have received the copy of the entire file.
And this was 25th August.
I'm engaged as amicus curiae by my lords.
All right, sir. All right. 25th August, sir.
My lord, if the list is exhausted, may I take a while from your lordship, my lord? Am I permitted to take a while from your lordship, my lord?
Yes.
In fact, my lord, item number 36, I am supposed to not press that. But unfortunately, I could not appear, my lord. Your lordship might have recorded non-appears, therefore your lordship.
All right. 36, you said dismisses not press. All right.
With due respect, my lord, I am sorry to disturb. In item number 22, there are 11 applicants for the class C post, damaged building worker. And the so-called incorporation is being made is not necessary because I have filed judgments of 3 high courts of recent, and the latest one was on 19th of April, with no amendment is there. I have filed that on 13th. 19/4/2022 is the order judgment of Madhya Pradesh High Court, Jabalpur bench. And the next one I have filed is of Bombay High Court, Nagpur bench, disposed on 31st March 2022. And the third one I have filed is of Madras High Court, and it was disposed of 3rd of December 2021. In all the cases, the opposite parties are same as in my writ petition. So no change is necessary. To that effect, I have earlier also filed a notification of the Ministry of Defense, and that is dated 4th of March 2022. And that is on record. That was in compliance to my recorded in judgment in order dated 13/4/2022.
All right. All right.
But my case will become infectious, my lord.
All right.
For judgment, JCRLA 64 of 2016.
In view of such direct and cogent evidence with regard to assault and subsequent conduct to screen the evidence of murder, the charges under section 302 by 201 of the IPC are clearly established against the appellant beyond all reasonable doubts. Thus, in the result, the conviction and sentence is confirmed and the appeal is dismissed.